Pipeline Hazardous Materials Safety Administration. The Pipeline Hazardous Materials Safety Administration, United States of America. The Office of Hazardous Material Enforcement Operation Manual. Chapter 5, General Inspection and Procedure, Section 5.1, Definition. The purpose of the chapter is the following definition applies. Inspection. The term inspection includes inspections authorized under the 5121C. Investigators authorized under Section 5121A of the Hazardous Material Law 49 U.S.C. Code 5101, etc. The term person is defined in Federal Hazardous Material Hazardous law means individual, firm, or co-partnership, cooperation, company, association, joint stock association, including any trustee, receiver, assignee, or representative, thorough, and including the government, Indian tribe, authority of the government or tribe, otherwise in the hazardous material for the transportation and commerce, transportate hazardous material to the firm. Furthermore, commercial enterprise of design, manufacturers, container, and packaging component of the representative mark certified or sold as qualified as transporting hazardous material in commerce, but such terms does not include an unstated postal service, and for purpose of imposing civil and criminal penalties at department, agency, and instrumental and federal government. 49 U.S.C. Section 5102-9, imminent hazard. The term imminent hazard means an existence of a condition related to a hazardous material present substantial likelihood of death, serious and illness, and severe personal injury, substantial endangerment, and health, property, environmental may occur that responsibility for suitable completion date of formal proceedings begun to lessen the risk of the death, illness, injury, and endangerment. 49 U.S. Standard Code, Section 51025. Section 5.2, Investigation Duty. Your primary duty to determine compliance with the safety standards and inspection and investigation of the person who offers hazardous material for transportation, manufacture, recondition, retesting, packaging, used to transport hazardous material, facilities, and handles intermodular transfers and hazardous materials. Section 5.3, Advance Notice of Inspection. You are not required to give a person advice notice of an inspection. Moreover, the policy of PHMSA Hazardous Material Enforcement Program to conduct an unannounced inspection and affords that the investigator or candidate view of the normal business operations. Thus, you should avoid giving advance notice of an inspection. If an advance notice is necessary in order to conduct an effective inspection, prior approval must be obtained by your supervisor, director of the OHME. Advance notice of inspection may be given only in the following situations: in cases of apparent immediate danger, to enable the company to correct danger as quickly as possible, when the inspection must effectively be conducted after regular business hours, when special preparations are necessary to ensure presence of records, equipment, officials, and other appropriate personnel who are determined by supervisors are needed to aid in the inspection, and in circumstances including the A, B, and C, when the supervisor of director OHME determines to give an advance notice when enhanced probability of an effective, thorough inspection. Section 5.4, Entry of property of others. Inspection with the conduction of the regular working hours of facility inspected, inspecting in special circumstances. Your official credentials is your authority to enter upon, and to inspect and examine lands and buildings and equipment, to inspect and copy records and papers of shippers and other persons in performance of your duties and authorized in federal hazmat law. Upon entry and immediately identifying yourself into a courteous manner, state and purpose of visit and present in a business card. You should display your official credentials when requested into the facility. When you're determined that it is necessary to carry out your official duties, the credentials may not be reproduced. Do not allow anyone to make a photocopy, photograph, or any other reproduction of them. Section 5, the refusal and to permit inspection. If a person refuses to allow inspection, you should tactfully but firmly advise the person that Federal Hazard Transportation Law authorizes such inspections, and you should presently later be in letter of introduction which was prepared for this Purpose. A copy of letter introduction located in Appendix A, and if a person is still denied, you shall, when possible and certain, reason for season refusal, shall leave the premises, immediately report the circumstance to your supervisor. Supervisor shall be Director of OHME, the Assistant and the Chief Counsel, Hazardous Material Law of their staff under no circumstances. You to engage in a dispute of any after being denied and permission to induction of an inspection, and if Director OHME, Assistant of Chief Counsel determined of the inspection must be transpired, Assistant of Chief Counsel of his staff that will prepare documentation to support warranty into inspections facilities and provide inspections to you and to obtain the warranty. The warranty has been obtained. You shall return the facilities with the original letter of introduction and the warranty. If the entry is still denied, you shall leave the premises immediately and notify your supervisor. Your supervisor shall not consult the Director of OHME. Section 5.6. The interference with the inspection. In case when entry of the premises has been allowed and the person interferes with the limits of an important aspect of the inspection, failure to produce vital records or other documents, failure to answer material questions, failure to give statements or interview, you shall be determined whether to be complete or discontinue the inspection. You shall notify the supervisor in circumstance, including information of enforcement report. If the Director of OHME, the Assistant Chief Counsel, determines the additional information is necessary to complete the inspection of Chief Counsel, will prepare the documentation, support the warrant, and subpoena as an authority. If the encounter forcibly resistance is performance of your duties and threatened in a manner, you should immediately withdraw from the scene, reporting from the circumstances to the supervisor immediately. Section 5.7, the waiver of responsibility. You shall not sign any form of release waiver that applies before the entering of the premises of each person who is subjected to hazardous material regulations. You may sign statements in which you are to agree to abide to the safety rules established by the company, which could include attending a safety briefing and viewing safety films or videotapes, wearing specified safety equipment. You may sign a visitor or sign or guest register or used to control entry to the premises, provided the signature does not constitute any form of release or waiver of responsibility, does not limit or prohibit your access to the area that must enter the conduct an official business, or you ensure the legal effect of the document to be signed, consulted with the supervisor prior to signing the document. If you are warranted, the supervisor shall consult with the Director of OHME, and a person expresses concern or priority considerations. You may include the result of an inspection and disclose only as required. In addition, any question about documents under the Freedom of Information Act, the FOIU request is screened and signed for priority information prior to release. The person who provides the information to the government is to advise the request and given the opportunity to state the material should not be released in the requested. Section 5.8, striker and a labor dispute. Do not conduct an inspection of the property of a person during a strike, work stoppage, picketing, or property expect that undergo guidance of a supervisor. Section 5.9, usual problems and occurrence. Notify your supervisor unusual problem occurrence related to an inspection. You should be required. Your supervisor shall be the Director of OHME. Unusual occurrences have been documented in internal summary portion of the enforcement report of the MHIS. Section 5.10, imminent hazardous and potential violations. Do advise parties of regulatory requirements, penalty, consequences, non-compliance. If no one else has advised an emergency response agency of an imminent hazard to do so. Do not order a direct party to take or not take any specific action. Occasionally, you may inquire a situation involving an imminent hazard or the possibility someone intends to continuing to violate regulations. You need to appropriate action to promote safety and be careful to do so in appropriate manner. And if an imminent hazard exists, no one else has advised an appropriate emergency response agency, you should do so immediately. You should ensure the involved parties are aware and responsibility under regulations. You should not take charge and attempt to carry out responsibility of regulated parties. Although you may may advise involved parties the applicable requirements. Prohibition may be very careful not to order. Direct instruction, mandate in particular action to be taken. Ordering and directing an instruction mandating that the action to be taken out that and taken an action not to be taken is beyond the scope of the authority could result in personal legal liability. Instead of giving orders or directions, advise involved parties the regulation requires to enable those parties to comply with the regulation. You may advise the party that the failure to comply with the regulation could result in imposition of civil penalties. When a party appears to need additional reason to comply with the regulations, you may certainly state that the party has now been advised and regulations require and prohibit the party's subsequent violation of those regulations could be considered willful and thus subjected to possible criminal prosecution. There is a significant difference in one, telling someone with a regulation require that prohibit, and two, ordering someone to do something prohibiting someone from doing something later in actions that carries a much greater lawsuit and liability alleged damages. The following example of the indifferences: assume the discovery hazardous material company shipping docks and non-UN standard packaging that do not comply with regulations appear with shipment them is likely. You should advise the company: 1. The shipping requirements of the hazardous material is involved. 2. The failures to comply with the regulations could result in substantial civil penalty for the shipper and the carrier. 3. If necessary, advise the company individual employees may be subject to criminal prosecution if they proceed to violate the regulation because you have just told them what the regulations require, and violation less would be willful. On the other hand, you would should not prohibit the company for shipping hazardous material until they are properly packaged. The distinction between advising and ordering is critical, and that you should even say that you are ordering, prohibiting a specific action. In example, therefore, you might say that the regulation, specifically 49 Code Federal Registry blank, require that the state hazardous materials to be shipped and transported in U.S. standard packaging, specifically blank. If they are shipped, offered in transportation packaging that does not meet the requirements, the company involved may be subjected to civil penalty up to $50,000 per violation, $100,000 if someone is injured or killed. Also, carrier is likely to be subjected to the similar civil penalties. In addition, because I have told you the regulations require, if you go ahead and ship these hazardous materials in the packaging, you are personally the company and may be subjected to the criminal involving up to the 5-year imprisonment and the fines of $250,000. I am not telling you what to do or order you. I'm simply telling you the regulations require and penalties prescribed could be the violation of them doing you. Understand, any listener should clearly understand that they are not ordering anything to be done or not to be done. Or not done. To be done or not done. Because the importance of what you say, write down the statement just after making it. Also, you may statement another investigator and law enforcement official, some neutral party witness, and other impacted parties, and may be later prove to be useful. This is the copyright of Opsman Man 7-01705, chapter 5.